Today, in the media conference with Lal Goel, which is brought to you by V4 News, Global TV, V4 Stream, Malnadu TV, News Gaon Se, Samvad Sarokar News, Organ Donation India Foundation and Gyan, our endeavor is to enlighten you about the current topics. And today the current topic is daughter-in-law's right to stay in property. Before I will start on the topic, I would like to inform that today the world is celebrating United Nations Day. The United Nations officially came into existence on 24th October 1945. In 1947, the United Nations General Assembly declared 24th October the anniversary of the Charter of the United Nations, as which shall be devoted to making known to the people of the world the aims and achievements of the United Nations and to gaining their support for its work. The year 2020 marks the 75th anniversary of the United Nations and its founding charter. This anniversary comes in a time of great disruption for the world, compounded by an unprecedented global health crisis due to the COVID-19 pandemic with severe economic and social impacts. But it is also a reminder that times of struggle can become an opportunity for positive changes and transformation. The COVID-19 pandemic has reminded us in the most powerful way that we are closely interconnected, and only by working together and in solidarity we can build resilience against future pandemic and other global challenges. We extend our greetings and sincerely hope that United Nations will play an important role in keeping peace and harmony in the world. We are also celebrating World Polio Day. World Polio Day was established by Rotary International over a decade ago to commemorate the birth of Jonas Salk, who led the first team to develop a vaccine against poliomyelitis. Use of this inactivated poliovirus vaccine and subsequent widespread use of the oral poliovirus developed by Albert Sabin led to the establishment of the Global Polio Eradication Initiative GPEI in 1988. Since then, GPEI has reduced polio worldwide by 99%. We are sure Rotary International and other service clubs will also play a very important role in eradicating coronavirus. Now coming to today's topic, that is daughter-in-law's right to stay in property. The Supreme Court on October 15th revised its previous ruling on the Domestic Violence Act and said that the daughter-in-law have the right to stay at their in-law's house. In effect, Indian women can now claim residential rights at her in-law house both during and after domestic violence proceedings. The bench also termed as incorrect law and set aside an earlier judgment's interpretations of definition of shared household under the Act and said that the definition was quite exhaustive and intended to provide the residence to the victim women under the law. In a big win for married women who are mistreated or tortured at their in-laws, the top court has observed that the wife would have the right to claim the shared household of the joint family under the Domestic Violence Act. Shared household refers to property owned by a woman's husband or by the joint family of which the husband is a member. This does not include self-acquired property of any family member. A three-judge Supreme Court bench headed by Honorable Justice Ashok Bhushan said as per the definition of shared household in Section 2S of the Domestic Violence Act, a woman who has been subject to domestic violence has the legal right to the shared household of the family and also ancestral house of the mother-in-law. Deliberating in details about the provisions of the Protection of Women from Domestic Violence Act 2005, the Apex Court said the progress of any society depends on its ability to protect and promote the rights of its women. guaranteeing equal rights and privileges to women by the Constitution had marked the step towards the transformation of the status of the women in this country, it said. The Supreme Court had held in its 2005 order that a wife would be entitled to a shared household only if the aggrieved person lives there or had lived in a domestic relationship in the past. Notably, Section 17(1) of the Domestic Violence Act states that every woman in a domestic relationship will have the legal right to reside in a shared household regardless of a title or beneficial interest in it. Now, to discuss this judgment, which has created a ripple among the not only the among the legal fraternity but the society at large. We have a very elite, informed, experienced, educated panel with us. I would like to invite my first guest, and he is Advocate Ramesh Kumar Sharma. Advocate Sharma is a leading civil lawyer of Western UP. He is also appearing in Supreme Court and High Courts. He is dealing exclusively in the civil matters. He is rendering social service and connected with many institutions. He is founder secretary of Civil Lawyers Forum and president thereafter. He always participates in social activities. Welcome, Advocate Ramesh Kumar Sharma on our show. Advocate Sharma, this judgment which has come has created some commotion among the legal fraternity as well as the society. Now, we would like to know and understand how and why this judgment is bit in limelight, because so many judgments are coming, but only few judgments where there is a repercussion from the legal fraternity as well as the society. So for that, we would like to know about the daughter-in-law's right in property to stay in property. Advocate Ramesh Kumar Sharma, please.
Firstly, Mr. Goel, I am thankful to you to organize such a webinar on this subject. This is actually to educate the public at large. Through such webinars, legally technical matters may also be made understood to the public in a simple language, and that is a big achievement of the webinar. Now, coming to the topic, it is a legal and moral obligation of the husband to maintain his wife. Naturally, it is a right of the wife to be maintained by the husband. This right to be maintained includes a right of residence also. So it is the legal and moral obligation of the husband to make a provision for the residence of the wife. Generally, they do it, but the dispute, whenever the dispute creates, then this problem comes. In spite of the dispute, until and unless the relationship of husband and wife is terminated by a decree of divorce, this obligation exists as it is. Meaning thereby, in spite of all disputes during pendency of all litigations, the husband has to maintain and make a provision for the residence of the wife unless the marriage is dissolved by the competent court of law. Now, this obligation is only up to the lifetime of the husband. If due to any reason the husband passed away, then and the wife is unable to maintain herself from the property of the husband, or she is unable to maintain herself through her children, then it is the legal obligation as per Hindu Adoption Maintenance Act. Legal obligation is of the father-in-law to maintain the widow wife and her children. That's also a statutory duty and liability of the father-in-law. But that is only after the death of the husband, that is the son of the father, and not his lifetime. Now, after the death of the husband, as father has to maintain it, but generally these all obligations are being fulfilled by the father-in-law and the husband, and ordinarily the wives are being resided in the husband of the house or father-in-law. Whenever a dispute is being created due to any reason between husband and wife, then only such problems comes into play. Now, if that problems comes into play, the duty of husband remains as it is. He has to maintain the wife. He has to make a provision for the residence of the wife. Till 15th of October, as you have said, the law was, there was a judgment of 2006 of Honorable Supreme Court in S.R. Batra's case, that wife is having a right of residence in the house either owned by the husband or tenanted by the husband, or in which the husband is a co-owner or having a shareholding. But she is not entitled to having a right of residence in the house owned by the parents of the husband. That was the law. And that law was continuing up to now. But now, after this judgment, that entire provision of law has been overruled, the previous law has been overruled, and a new philosophy has been created by our Honorable Supreme Court. And now it has been settled that wife is also having a right of residence in the property exclusively owned by the mother-in-law or the father-in-law. Definitely, this judgment is going to create a chaos in the society. And with very great respect to the Honorable Supreme Court, I am also having some reservations about this judgment. My view is that Honorable Supreme Court has could not consider so many other laws, connected laws, and the provisions of the Constitution of India. Though the judgment is very lengthy, it is 151 pages, and mainly the provisions have been interpreted, as you have said, the domestic household, the word respondent, that has been interpreted. And after interpretation of these things, the Honorable Supreme Court has come to the conclusion, yes, wife is having the right. My view is, there is an act, Maintenance and Welfare of Parents and Senior Citizens Act 2007. And as per section 3 of that act, this act is having a overriding effect. This is important. The Domestic Violence Act is of 2005 and this act is of 2007. Its section 3 says, the provisions of this act shall have effect, notwithstanding anything inconsistent therewith, contained in any other enactment other than this act, or in any instrument having effect by virtue of any enactment other than this act. So this 2007 act has been given an overriding effect to all other statutes. Now, in this act, the provision is there that if a parent does not want to allow their son and daughter-in-law to be resided in their old house, they may evict them. It is their right. And nowadays, this litigation is increasing very high, particularly in the metropolitan cities. It is going very high in Delhi, Bombay, Bangalore, Pune, Chennai, Calcutta. It is increasing very high. And so many reported judgments are there on the point. And now the Supreme Court was also had in this act that if the property is being owned by the senior citizens and they don't want to allow due to any reason that their son and daughter-in-law should reside in their house, they can evict them and the son and daughter-in-law cannot reside there. Now, this principle of this act of 2007 has not been considered in this judgment of 15th of October. It has not been touched at all. And the provisions of this 2007 Act have been given an overriding effect, and Domestic Violence Act is an act of 2005. So this is having overriding effect, but it has not been considered. Now, net effect of this judgment is, the new judgment of Honorable Supreme Court, that the wife is having a right, the daughter-in-law is having a right to reside in the house of the parents of the husband, which is absolutely contrary to the provisions of this 2007 Act. And this will also create a chaos in the society because of all these things comes into picture when the relationship in between the family members are not good, either in between husband and wife, in between daughter-in-law, mother-in-law, father-in-law, sister-in-law, mother-in-law, whatever it is, then only these things came. And when amicable relationship is not there, and one person is being forcibly allowed to be resided in the house, it will totally destroy the peaceful and amicable life of the parents of the husband, definitely. And that will create further problems, either violence, suicide, or so many things. Another thing is, if wife, daughter-in-law is residing in the house of the husband's parents, then the parents have to make a provision for food and other necessities of the daughter-in-law. Otherwise, if they are not doing so, it shall be another domestic violence to her, and another case shall be there. So it is further increasing the litigations and the problems in the society. And this aspect has also not been considered in this judgment. The next thing is, right to property is a constitutional right in our constitution. Previously, up to 1971, it was a fundamental right. But in Mrs. Gandhi's regime, this provision was deleted from the list of the fundamental rights, and Article 300A was separately inserted in the Constitution. So it is no more a fundamental right, but it is a constitutionally guaranteed right. And right to property includes a right to peaceful enjoyment of the property. Now, this judgment is disturbing that peaceful enjoyment of the property. So this again seems to be against the Article 300A of our Constitution, by which a guarantee has been given by the Constitution. You are owner of the property. You are entitled to use or enjoy the property peacefully. This aspect has also not been considered in this judgment. Another important aspect is, if we come to the Domestic Violence Act, it is having two parts. In first part, if a domestic violence has been committed by any domestic relationship, the word has been used, domestic relationship. It may be mother-in-law, father-in-law, husband, sister-in-law, brother-in-law, whoever may be. Then the daughter-in-law is having a right to make a complaint in this provision to the concerned magistrate. And this is offense. This is punishable. We totally agree to that principle. If someone is committing an offense, doing some violence to some lady, either mental or physical, they must be punished. This is absolutely correct. The other aspect of this act is about the property rights. And as you have referred section 17 of this act, this section 17 of this act is totally independent to the right, to the matter of the domestic violence. Section 17, the plain and simple language says, notwithstanding anything contained in any other law of time being in force, every woman in a domestic relationship shall have the right to reside in the shared household, whether or not she has any right, title, or beneficial interest in the same. So this right is, shall word has been used, this is a mandatory, and this right is quite independent to the violence committed in the first part of the act. As per this section, even if there is no domestic violence, then also the daughter-in-law is having a right to reside in the husband's property, as per this section. But in this judgment, a new thing has been done, that this right of residence can only be claimed if a domestic violence has been committed. If no domestic violence has been committed, then this right of residence to the daughter-in-law is not permissible as per this judgment. With very great respect to the honorable judges of the Supreme Court, this doesn't seems to be in accordance with the scheme of this act. They have only stressed the interpretation of one word, respondent. Because of this word has been used in both the places, that is firstly with regard to the offense, and secondly with regard to the right in the property. Now this respondent word has been used in two different modes, two different provisions. It should be interpreted separately. But they have interpreted it that whoever is made a violence, he is a respondent, and only the such person who has made a violence, he is responsible to retain, to remain, or to permit his daughter-in-law to their property. This is also again going against the daughter-in-law, because of, if father-in-law and mother-in-law has not committed any domestic violence at all, the lady shall not be entitled to have any right to residence in their property. This is the pure and simple meaning of this judgment. So this part of the judgment is again going to the daughter-in-law, or I should say, whatever is being given by this judgment by one hand, the same is being taken away by the other hand. So the net result is zero. Because of in every case, whenever a daughter-in-law says I am having a right to reside in the property of the husband and of the parent of the husband, they will simply say we have not made any violence to our daughter-in-law, and she is not entitled to reside in our house. So she will get nothing. So this judgment seems to be a self-contrary also. This word respondent must have been interpreted separately and not simultaneously at both the places. And it must have been given a separate result using in section 17 and using section 5 and 7 with regard to the offense. Generally also, the offense is being governed by the provisions of the criminal code of procedure. They are being conducted in the criminal courts, and this right to property that relates to the civil law and civil procedure code is made applicable in the property matters. In this case also, the CPC has been made applicable. With regard to the offense, the CRPC has been made applicable. But in interpretation of the word respondent in this judgment, with very great respect, I feel the Honorable Supreme Court has committed a mistake, and the interpretation which has been taken by the Honorable Supreme Court is not correct. Whatever they have given in the first part of the judgment, they have taken it back from the other part of the judgment. So the net result is just nothing, and the ladies are going to get nothing out of this judgment.
Okay. Thank you, Advocate Ramesh Kumar Sharma. And according to Advocate Sharma, the Supreme Court had committed a mistake. I will not use the word committed, but in the judgment, Advocate Sharma is not happy with the judgment. According to Advocate Sharma, there's a contradiction in the judgment. One side, Supreme Court's intention was to give the rights to the daughter-in-law to reside in the house of the father-in-law and mother-in-law, even when the domestic violence has been committed or a dependency of the case. The other side is that if there is no domestic violence and if the parents doesn't want that they should stay, then the daughter-in-law has to vacate the house. And according to Advocate Sharma, there are 2 or 3 basic contradictions, because the Domestic Violence Act was of 2005, and in 2007 there was another act which was right to property. No, which one was that?
Maintenance and Welfare of Parents and Senior Citizen Act.
For the senior maintenance,
Senior Citizen Act.
Yes, maintenance, and for the maintenance of the Senior Citizens Act, that says that the senior citizens have a right, if there is if they are not happy with their children, whether the son or the daughter-in-law, so they can ask them to leave the house. So according to Advocate Sharma, this is not clear, and it is going to create a chaos in the society, because we are in a closely knit society where the daughter-in-law stays even after the death of the husband in the in-laws house only, without any complications. But now, after this judgment, there may be many cases will come up where the daughter-in-law will be asked to leave, and the in-laws can say that we have not committed any domestic violence, and then the sufferer will be the daughter-in-law. Thank you, Advocate Ramesh Kumar Sharma, for giving your strong views about and the frank views about this judgment. Now I would like to invite my second guest. He is Mr. Karthik Anand. Mr. Karthik Anand is the Assistant Professor of Law at SDM Law College, Mangalore. Mr. Anand has completed his BA, LLB and LLM in Business and Trade Law from SDM Law College, Mangalore in the year 2013 and 2015 respectively. He has secured first rank with 2 gold medals in LLM KSLU. Mr. Anand has five years of teaching experience and has attended and presented papers at various seminars and conferences, and also co-edited a book, Compendium on Legal Issues, published for YASHAS for Civil Services Examination Aspirants. Welcome, Mr. Karthik Anand, to our show. Mr. Karthik Anand, you have heard what Advocate Ramesh Kumar Sharma has mentioned, and
Yes, sir.
he has given all the views, all his interpretation of the judgment, and he says that this is a self-contradictory judgment, and it has to be. He has not mentioned, but his views are that it has to be reviewed because it is some places, many places, it's for the benefit of the daughter-in-law, but other places it's harming the interest of the daughter-in-law. So according to Advocate Ramesh Kumar Sharma, Supreme Court has given some places to the rights to the daughter-in-law and taking the rights back, and the end result is zero. Now we would like to know from you about on the topic, that is the daughter-in-law's right to stay in property. Mr. Karthik Anand, please.
Yes, sir. So before starting the discussion, I would like to thanks to Mr. Lal Goel, sir, give me an opportunity to address such a recent issue related to the verdict of the Supreme Court by granting right to daughter-in-law reside in the shared household, even if her husband had no legal right to the house and the same was owned by the father-in-law or mother-in-law. So in India, there are few judgments of the courts which actually judges life of a common man very intimately. And the present judgment also important not only for the common man, it is important as an academic viewpoint also. So one such judgment was delivered on 15th October 2020 by the Apex Court, which redefined in the concept of what is shared household in Domestic Violence Act. So, by delivering the decision, the Apex Court categorically emphasized that domestic violence in this nation is rampant yet underreported. Several women encounter violence in some form or the other almost every day. However, it is the least reported form of cruel behavior. A woman resigns her fate to the never ending cycle of enduring violence and discrimination as a daughter, sister, a wife, a mother, a partner, or a single woman in her lifetime. So, even cases of domestic violence carry a social stigma against the wife, as a woman are expected to be subservient. So while moving on to the today's discussion evolving around, in the verdict came on a petition filed by a 76-year-old Delhi resident, Satish Chandra Ahuja, the father-in-law of the woman, challenging a Delhi High Court judgment setting aside an order of a trial court passed in 2019 directing daughter-in-law to vacate his premises. So in the present case, appellant Satish Chandra Ahuja, by relying on the decision of S.R. Batra and another versus Tarun Batra and others 2007 case, where two judges bench of the Supreme Court held that the wife is entitled only to claim a right under section 17 plus 1, that is residence order, in a shared household. And a shared household would only mean the house belonging to all taken on rent by the husband, or the house which belongs to the joint family of which the husband is a member. But on the other side, the respondent, that is her daughter-in-law, she submitted that Domestic Violence Act 2005 granted protection and security of residence to a woman. The definition of domestic relationship under Section 2F brings appellant in its fold, and so the said house is a shared household under Section 2H. So in the present case, the main discussion around what is actually meant by shared household under the Domestic Violence Act, and father-in-law can be impeded as a respondent when the husband did not have any separate property. So on the other side, where the father-in-law can evict the daughter-in-law on his property according to the due process. So before discussing the issue, I would like to make your attention to the two important definitions under Domestic Violence Act. First is what is meant by domestic relationship and what is meant by shared household. So under section 2F of the Domestic Violence Act provides, domestic relationship means a relationship between two persons who live or have at any point of time lived together in a shared household when they are related by consanguinity, marriage, or through a relationship in the nature of marriage, adoption, or family members living together as a joint family. So what is meant by shared household? And same word ambiguity to a certain extent solved in the present case, which is created in the SL Batra case. So what is meant by sharehold? Under the original act, under section 2S defines sharehold means, or shared household means a household where the person aggrieved lives in a domestic relationship either singly or along with the respondent, and include such a household whether owned or tenanted either jointly by the aggrieved person and the respondent, or owned or tenanted by either of them, in respect of which either the aggrieved person or the respondent or both jointly or singly have any right, title, interest, or equity, and includes such a household which may belong to the joint family or which the respondent is a member, irrespective of whether the respondent or the aggrieved person has any right, title, or interest in the shared household. So, from the above definition under section 2A makes clear that, as per the law, or it is not a requirement of law that a aggrieved person may either own the premises jointly or singly, the household may belong to a joint family of which the respondent is a member, irrespective of whether the respondent or the aggrieved person has any right, title, or interest in the shared household. And the shared household may either be owned or tenanted by the respondent, singly or jointly. So section 2 is an exhaustive definition because shared household cannot be limited to the shared household of the joint family of which husband is a member or in which husband has a share. So the entire scheme of the DV Act is to provide immediate relief to the aggrieved person with respect to the shared household where the aggrieved person lives or has lived is immaterial. So second question before the Supreme Court, whether judgment of the Apex Court in SR Batra and another versus Tarun Batra 2007 3 SEC 169 does not lay down a correct law. So for that, how the Supreme Court has been evaluated, the interpretation which is put forth by court in SR Batra case, if accepted, shall clearly frustrate the object and purpose of the act. So even Supreme Court held that the interpretation of shared household as put by the court in SL Batra case is not correct interpretation, and the said judgment does not lay down the correct law because in the case held that wife is entitled only to claim a right under section 17 clause 1 to residence in a shared household, and a shared household would only mean the house belonging to or taken on rent by the husband, or the house which belongs to the joint family of which the husband is a member. So, on the basis of this, the shared household belongs to any relative of the husband with whom, in a domestic relationship, the woman has lived. The condition mentioned in section 2 is satisfied, and the said house will become a shared household. So, the Supreme Court has clearly said that there is no necessity or it is immaterial. Whether she has been actually lived or not, it is immaterial. They have to establish a certain sort of domestic relationship. Then she can claim right over the property of the father-in-law. So next question arises whether father-in-law can be said to be the respondent as per definition of section 2Q of the Domestic Violence Act 2005. So in the present case, father-in-law can be treated as a respondent, but for grant of relief as prescribed under the Act of 2005, it has to be pleaded and proved by the daughter-in-law. Only then the relief can be granted by the civil court. So the definition of respondent does not include only husbands, the relatives of the husband who have treated the aggrieved person with domestic violence can be allied as a respondent. So there is no reason to extend definition of the shared household only to property in which the husband has a share. Even father-in-law also within the meaning of the respondent. So another question is, what is the meaning and extent of the expression save in accordance with the procedure established by law, which is occurring in section 17 clause 2 of Domestic Violence Act. So subsection 2 of section 17 contemplate that any aggrieved person can be evicted or excluded from the shared household in accordance with the procedure established by law. So this embargo is only against respondent as defined under 2005 Act. So he can also move under the Civil Procedure Code for the eviction of the respondent, daughter-in-law, and it has to separately decided based on the pleadings and evidence before the trial court. So that is why even High Court also said that if they are interested, the daughter-in-law has to prove before the trial court because it makes a clear consistency between Order 12 of the CPC as well as Domestic Violence Act. Both are considered as a separate proceedings. One proceeding should not override proceedings under the Domestic Violence Act. For the eviction, there are separate law has been provided. So the interest of the senior citizen also will be protected by evicting the daughter-in-law if there is without domestic violence, if any false complaint has been filed by the daughter-in-law against father-in-law. So again, whether the next question before the Supreme Court, whether the husband of the aggrieved wife is a necessary party in the suit by the father-in-law against the daughter-in-law. In the sense, whether husband can be impeded as a respondent, because first respond appellant in this case is the father-in-law, not the husband, not the husband. So this part also discussed in the length and held that it is left to the trial court. However, the High Court in this case ought to have given a general direction. This needs to be considered by the court, taking into consideration all aspects of the matter. Even Supreme Court replied to this question that although the husband of the defendant was not a necessary party, but in view of the pleadings in the written statement, the husband was a proper party. So he was within the domestic relationship, therefore he can be impeded as a respondent number two. So everything depends upon fact and circumstances of the each case. In this case, on the basis of the High Court general direction, the husband has been incorporated as a respondent. So final question before the court is, what is the effect of orders passed under section 19 of the Act, which provide it may be order, may be any interim or final order. So whether interim or final order passed in the proceedings initiated in a civil court of competent jurisdiction, whether both will run together. So the pendency proceedings under the Act 2005 or any order interim or final passed under the Domestic Violence Act under Section 19 regarding right of residence is not an embargo for initiating or continuing any civil proceedings which relate to the subject matter of order interim or final passed in the proceedings under Domestic Violence Act, which interest of the owner of the house has to be protected. So finally, I would like to conclude that this is one of the beautiful judgments, but at the same time creates certain ambiguity in the minds of the common man related to the daughter-in-law's right to stay in property. Because, well, one hand there is an aggrieved woman, and on the other hand there is a senior citizen. Both right has to take care who have filed a civil suit to evict the daughter-in-law. Another side, protection of woman's right. Therefore, what is my opinion? Each case must be decided on its own merits and pleadings without giving much chance to taking advantage of the laws. Where the protection for the woman is needed, our right must be safeguarded. At the same time, no woman should use the laws for taking undue advantage over the another person. Thank you, sir.
Thank you very much, Mr. Karthik Anand, for giving your views. And according to Mr. Karthik Anand, this is a very good judgment. Some ambiguities are there. And according to him, that the lower court should decide on the merits of the case individually, depending on what is the case. If the senior citizens has been harassed by the daughter-in-law, then definitely the daughter-in-law can be evacuated, according to Mr. Karthik Anand. And in case if the senior citizens are creating problem for the daughter-in-law, then daughter-in-law have right to stay in the property of shared property. Correct, Mr. Karthik Anand, what I have said is correct? Because it's a
Yes,
legal
sir.
thing. I do not want to give any wrong message. What you
Yes,
have
sir,
said
yes.
is okay. Thank you very much. Thank you, Mr. Karthik Anand, for giving your interpretation complete in details about the. I think that is the reason of a academician advocate to be there on the board. Thank you very much, Mr. Anand, for giving so many details. Now I would like to go and invite my next guest, and he is Advocate Arjun Drone. Advocate Arjun Drone is the proprietor of Arjun Drone and Associates, New Delhi. He is an experienced legal professional with law degree from MET Law School, Noida. He is specialized in criminal and consumer law. He appears in district court, high courts, and NCDRC. At present, he is handling cases in Delhi, Lucknow, and Mumbai. Welcome, Mr. Advocate Arjun Drone on our show. Advocate Arjun Drone, you have heard what Advocate Ramesh Kumar Sharma as well as Mr. Karthik Anand has mentioned, and both have given their views. According to Advocate Ramesh Kumar Sharma, there are lots of ambiguity or lots of contradiction is there in this judgment, Supreme Court judgment of 15th October. And he says that it is going to create a chaos in the society. While Mr. Karthik Anand welcomed this judgment, although he says there are some ambiguities there, which he is sure that the trial court will definitely decide on the merits of the case and take action accordingly. Now, we would like to know the views on the daughter-in-law's right into stay in property. Advocate Arjun Dron, please. Please unmute. Please unmute.
First of all, I would like to thank you for this opportunity to speak on this topic, which is such a recent topic for that matter. And I would also like to welcome Mr. Ramesh Sharma, who is a veteran senior who has spoken to the point on this topic. And also Mr. Karthik Anand, educated and has spoken in a very elaborate manner about this topic. First of all, I would like to welcome Mr. Ramesh Sharma's point of view. As practicing on the criminal side for a very long time, we have noticed one thing, that it is not just the legal point which has to be taken into consideration. It is also the human element involved which will be interpreting that particular law. Now, taking this point into consideration, that a lady has given the right to reside in a property only if she is filing a domestic violence case against her in-laws or her husband. This gives rise to additional litigation. Hello? In this situation,
Your net is weak,
now
Advocate
in
Drone.
this situation,
Okay, yes, go ahead. Please go ahead. Is there any other devices you have connected
now
on the same
with
net?
this point, we no, not at all, not at all.
Okay, please go ahead.
Am I audible?
Yeah, yes, please go ahead.
Now consider this fact that the human element to be involved in this particular situation. Now, for us to understand this thing even a bit more well as to why this law and every has come into force, I would like to give you a brief summary of the Supreme Court judgment, which was recently passed under the flagship of Justice Bhushan. Now, and the reason for which I will be reciting this entire case is to tell you the intricacies where there was so much ambiguity and the Supreme Court acted just on the just giving the woman empowerment as a baton to pass this judgment. Please. Now, on 1995, Mr. Sneha Ahuja and Ranveer Ahuja, they got married. Okay, I would like to inform that I am a criminal lawyer, so I go more towards the merit than the law. So please bear with me. Okay. So after the couple got married, staying together for 19 years, the husband Ranveer Ahuja and the wife Sneha Ahuja, who were living on the first floor of a shared building, moved to the ground floor as they were having some discord. Now, first point that should be taken into account is that the divorce petition was filed by Mr. Ranveer Ahuja, stating the fact that he has been subjected to emotional harassment from his wife. Similarly, the divorce petition was filed, and after the divorce petition was filed, to back fire over that particular complaint, Mr. Sneha Ahuja filed a domestic violence complaint within 6 months of the said activity. Now, understanding this point, now this particular activity is happening between the husband and the wife. Now, as Mr. Ramesh Sharma mentioned, that in the according to the Maintenance Act, which was passed in 2007, it is a separate issue. You cannot only give relevance to the women of the society. You have to give relevance to the old people also. The Mr. Satish Chandra Ahuja, who is the father-in-law of Ms. Sneha Ahuja, has had 2 bypass surgeries, is a heart patient, and is suffering from various illnesses. Now, considering this point, now the Supreme Court, where it lacked on a humanitarian basis, I would rather state is that when the civil suit was filed by Mr. Satish Chandra Ahuja, he just clearly stated that this is my property. I had bought it in the year 1983, ever since that, they have been residing in this property. Now, when in civil suit, when the reply is side of enduring mental harassment moves to the point of the ownership of the property. Now she is disputing the ownership of the property, which shows that it is not just a point of harassment which has been subjected from one side. It's a mutually harassed situation where it is the where it is Mr. Sneha and also the father-in-law and the mother-in-law who have been harassed in this case. Now, in this point, the Supreme Court came as a custodian of law for Mrs. Sneha Ahuja and amended in a way the judgment which was in S.R. Batra versus Tarun Batra in 2007, where it is mentioned that
I think we lost Advocate Drone, some internet problem. Once he will join again, then we will connect him again and we will take his views. And I would like to now go to the next.
Hello.
Yes, you are not there. Some problem is there. Is it correct,
Am I
Advocate?
audible now?
No, but we can't see. Advocate Sharma, can you now we can see you. Yes.
Yes.
Now, yes, you are there.
Okay.
Yes, we missed you. Some net problem is there. Yeah. Yes, go ahead, please.
Yeah. So what I was now in this point, the Supreme Court comes out as the custodian of custodian to protect the women right, changes the interpretation of Section 2S of the Domestic Violence Act and Section 17(1) of the Domestic Violence Act, which was interpreted in S.R. Batra versus Tarun Batra matter. Now, earlier it was stated that the or can only claim to reside in the property which is owned
Yes, go ahead.
is owned by her husband. Hello.
Yeah, go ahead, please. Please go ahead. No, I think what I suggest, Advocate Drone, if you can just move out from where you are and see if you can, because the net is a problem at wherever you are. We can't hear you or we can't see you. So now I'm going to the next guest. We will definitely like to hear what Advocate Drone is making, although he's made a important point, and he mentioned very clearly that he being a criminal lawyer, he would like to go to the merit of the case, and he was giving the details of all the details, how not only the harassment to the daughter-in-law, but it's a harassment to the in-laws also. But we could not hear his complete submission, so we will wait if it can come afterwards. Now I would like to move to my next guest, and she's Rotarian Akshita Nayak. Rotarian Akshita Nayak is MSc, is a counseling psychologist and founder chairperson Here to Here at Dharwad. She obtained her master's degree in psychology with a specialization in counseling from Christ University, Bangalore. Having done her thesis in depression and mental health, she has been working extensively in that area. In addition to that, she has been dealing with cases related to anxiety, de-addiction, relationship issues, stress and trauma, to name a few. She is the founder of an online counseling portal called Here to Here, established in a view to help people to have an easy access to counseling and therapy. Welcome, Ms. Akshita Nayak, on our show. Ms. Nayak, you have heard the legal luminary, I must say, Advocate Ramesh Kumar Sharma, Mr. Karthik Anand, and partially Advocate Arjun Drone. And all they are giving the views, although there was a contradicting views, I will say contradicting each other in few areas. But the main aspect of this judgment is it is going to impact the society at large, and it can even create a problem in the social fabric of our society. You being a psychologist, you are dealing with the mental health, not only of the daughter-in-law, but of the father-in-law and mother-in-law. After all, it's a family case. So we would like to know, once this is going to come on this, what is going to happen? And we want your views independently, although we know that you are a daughter-in-law also, but we want your professional views on the daughter-in-law's right to stay in property. Miss Akshita Nayak, please.
So thank you so much for giving a lovely introduction. And thank you for giving me an amazing opportunity to talk about this as well. So the topic that I'm going to talk about is the daughter-in-law's right to stay with the in-laws even after being estranged. So that is, the one I'm going to talk about. So to make it more precise, I will be taking up 5 points again. So that will be what is estrangement, what are the causes, what are the psychological impacts, and what are the implications that can come from this law over daughter-in-law, the parents-in-law or the family, and the husband, and also the negative implications that can come from this. Because as you mentioned, we have human values, as Mr. Drone also mentioned about this, that we have to take into consideration the psychological point of view when we are considering a law. So, first of all, what is family estrangement? So, if I have to give you simply, it is the loss of previously existing relationship between family members through physical or emotional distances. And that can often happen because of very minimal or negligent communication or no communication, and which is there for a long period of time. So, this is the definition of estrangement. So, estrangement comes with a lot of other problematic situations for the family members, for the husband, for the the daughter-in-law as well. So if we are considering what can be the causes of estrangement, so some of them can be sexual abuse, verbal abuse, physical abuse in the hands of the in-laws towards the daughter-in-law. It can be also because of neglect of emotional feelings, neglect of the needs of the daughter-in-law, or it can also happen because of certain misbehaviors that has happened because through the in-laws or the family of the in-laws as well. Another thing is conflict of disagreement between the in-laws and the daughter-in-law. If there is a disagreement, there can it can be one of the major causes of estrangement. And the main topic here is the family, between the members of the family. So here, when I'm talking about this, I would go on to the psychological implications. Now, what can be the psychological implications for the daughter-in-law if she's facing domestic abuse in the household that she's been married to? Obviously, I'm a daughter-in-law myself, so when I got married, obviously there were a lot of there are a lot of expectations that you have through a marriage, and you feel that your husband, your in-laws should take very good care of you. But women who have faced domestic abuse, it can come as a shock to them. There can be a lot of traumatic experiences that comes with it. Okay. So one very important thing is it can cause a lot of physical and mental decline in the well-being of the woman. So first, I'll be giving the psychological implications of the woman, the daughter-in-law, because that is the main topic here of discussion. So that can cause a lot of physical and psychological decline in the well-being. Secondly, social rejections. It is not very easy for a woman to go through, separation, divorce, or estrangement by her in-laws or by the husband. There is a lot of rejection in the society. She is not welcomed in the society very openly after, people get to know what has happened to her. And that comes mainly because the social rejection. So we have four important psychological necessities, the needs that we have, all of us as human beings, because we are all social beings. So there are four very important needs, human needs that we have. So one is the need to belong. We all have a very important need to belong in, the place that we are in. Probably it's the family, it's the community, or the society at large. Second need is to control, to have a control in the social situations. And social, when I'm telling social situations here, it's mostly the family. When we are in the family, we would want to have a control in the social situation, or how what happens in the family. But many a times women, now manifesting in the family, it can be a lot of problem for her. Then the last one is need for meaningful existence. All of us, we try finding the meaning of our existence, why we are alive and everything. But if in the household we are the lady is not able to find a meaningful existence, that can be a violation in her existence itself, in the need of why she's being in the family. Another very important psychological impact that can come from domestic violence is she can feel very loneliness which can cause other psychological problems for her, like depression or anxiety, things like that. Because I'm a psychologist, I will have to be considering all these points when I'm talking about domestic violence. So aggression, depression. So even I had a few clients who have been who had faced domestic violence, where under they were having court cases going on. So I could find a lot of aggression, anger in general, which was causing a lot of physical problems to them. So stress related problems, and also PTSD is post traumatic stress disorder. That has happened because of all the things that they have gone through when they are living in the house, when the domestic abuse was happening to them. Also when they had to repeat their the whatever happened, the experiences in the court, or when they were talking to the counselor or the psychologist. So when they were talking, so it was a repeated trauma that they had to go through again and again. That is what actually happens in the court of India as well, because we have to go there again and again and again and again, and we have to talk about the same thing that has happened. So a lot of post traumatic stress disorder happens, and which is very real in the scenario today. So when I'm going to my fourth point, it is about the implications that is there because of the new law that has been created. So I'll be giving 3 points of view here, in accordance with the in-laws, in accordance with the husband, and in accordance with the daughter-in-law. So when I'm talking about the in-laws, so I think this case is going to, if it is come out well, if it is spread well, I think it can come out in a way that in-laws are going to be more careful in the way they are going to deal with the daughter-in-laws henceforth. So I'm telling just the implications of what I feel could change, a reform, because most of it, of what I had read in the articles, it was the law that we have is more towards the men. It is more patriarchal. So now the government is trying, the court is trying to make our laws more women friendly. It is more for the equality of the women, and it can help the women. So in a way, if the laws have been put forward properly, if the women and the in-laws understand the law properly, probably they could be more considerate towards the daughter-in-law, or they could handle the family matters with more precision, and would want to resolve the problems that are happening within the household, in the house itself, and not let it go outside. So that is one very important thing. Secondly, most of the problems that arises today is because of the mindset of the people. So here it is mostly the expectations that the in-laws have over the daughter-in-law and what the daughter-in-law comes with. So there can be a lot of clashes. So if those things are not spoken about at the right time, probably it can cause problems later on, because all the things that we are talking about is in the household itself, that is happening in the household. It is the problem that is happening within the family. So if things have been resolved earlier, and if laws like these come, so it might help the in-laws well. And also, when I'm talking about the implication that that can happen on the husbands, I think I can give you a small example as to how, because of the rule that we have to wear helmets, and there's a law, that if you don't wear helmets, if you can be fined up to like 500 or 1,000 rupees, depending on that, on the region. So what has happened is men have started wearing helmets more often. At least some people are following the rule because they don't want to pay the fine. So if men also get to know about this law, that there is something, because what I've read through the of the article was that uh, women, whoever do not have any other place to go to, if they do not have a maternal home or they do not have any property to go to, then they can stay in the husband's house. So many men can take advantage of a situation like this and would think that the woman cannot do anything. But if the men get to know that women also have a cover, they are covered by the government, probably men would be more careful. They would be less abusive towards their wives, or they can be less aggressive towards their wives. So that can be one of the major implications. For the daughter-in-law, I feel she would hold a stance in the family. She also would be one of the person who could talk about or has rights to talk about, and because she would be knowing her rights, I think she would feel equal amidst the household. And secondly, I think it would also give her a form of security, because a woman who has children and who is facing domestic violence in the household might feel very insecure, and many women might back out from leaving their husbands because they do not have any other place to go to. But because of laws like this, I think women would feel more secure, and they would be approaching the court of law more often if they are facing problems in their household. So that I think can be the implications, positive implications for the women. But negative implication of what I feel from this law is that it can be misused. It can be misused by many women, and it can be taken, and the the justice wouldn't be rendered to the deserved parties, is what I feel sometimes. And also, I think it would be a very, very traumatic situation for a woman to be living in a household where she has been constantly abused, domestically abused. So because of this law, if this law is telling that the woman can continue staying with the in-laws, I think in the first place she has decided to leave the leave the husband or the in-laws for a specific reason, and this law is making them stay more with the in the family itself. So it can cause more trauma to the person, and more trauma means more mental health problems. So I think that has not been considered, and it can cause a lot of extra pain to the woman if that happens. So I think that would be some of the psychological
Okay.
implications.
Okay. Thank you very much, Ms. Akshta Nayak, for giving your views. Although being a daughter-in-law, you have mentioned very clearly your views. You are supporting this judgment. I think 98% of your talk says that it is a very good judgment, because you, according to Ms. Nayak, the lady who is suffering from the domestic violence, many times it happens she doesn't have any place to stay, and because of the trauma, if she feels that she can't go with the children, where she will go? Then she backed out, and she suffer the mental agony the whole life because of the domestic violence. And she has given the details about how the father-in-law, mother-in-law will change their attitude after this law. Once they know that that the daughter-in-law is having a right to stay, even the husband will be more careful while dealing with the wife, as well as the for the wife also, she will know, the daughter-in-law will know that what is her right in the household. So she will also act very positively according to Ms. Akshta Nayak. And she says there are negative points, that some women would like to misuse this law, but that is always, whenever there is a law, there are some black sheeps. But overall, Ms. Akshta Nayak is in favor of this judgment, and she is giving good review about this judgment, and she says that it's a good judgment, especially for the women. And for the psychological side also, she says that the women always have the trauma, mental trauma, which they are suffering, so it will give some relief. Thank you very much, Ms. Akshta Nayak, for giving your such a good analysis from the mental health point of view, because that is very much required, because the three advocates are giving their views. Now we will go back to them. Now I am asking Advocate Ramesh Sharma. Advocate Ramesh Sharma, there was a recent judgment on 12th of August, where the Supreme Court has given right to the daughter to have a right in the property of the parents' house.
Then to
Now,
family house.
now it means the daughter or the daughter-in-law have a two, I will use the word like two laddus in both the hands. One is they have the right with the judgment of 12th of August at the parental house as the share, as well as they have a right now in the in-laws house. So do you think it is more, although you have mentioned and that now the Supreme Court judges are considering more for the, they are inclined to give more relief or more advantages to the women with this judgment. What you say about this, Advocate Ramesh Sharma?
Yeah, Mr. Goel, this is absolutely correct. That not only the Supreme Court judges, but the legislatures are also framing the laws much more than the balance in favor of the women. This is absolutely correct. That right of equality is there in our constitution, and female gender should also be given a equal treatment in all aspects of life. And this legislation like this Domestic Violence Act, these are being called welfare statute. They have been meant to for the welfare of the women, for their protection from the domestic violence. Parallel to it, the 2007 Act, it has been enacted for the welfare of the senior citizens. Now, what I have said as earlier, so the basic principle of interpretation of statute is that we should interpret a statute so that it may not nullify or contradict any other statute. Now, whatever interpretation has been taken by the Honorable Supreme Court, this judgment, this is contradicting and nullifying the provisions of the Senior Citizen Act 2007. So that is against the basic principles of the interpretation of a statute. We must give a right to the daughter-in-law to a residence, and law is there till today. It is there prior to this judgment also, that a distressed wife is also to be maintained. That is, her residence is also to be provided by the husband. Even if she is not residing with the husband, she may rent out a house, and rent has to be paid by the husband regularly. That is the law. She is not on the streets. Her rights are totally protected. And that is the purpose, right of equality. The right of female gender should be protected. Now, by this judgment, those protected rights are being enlarged by the Honorable Supreme Court. Till now, it is only up to the property of the husband, and husband has a legal and moral liability to maintain the wife and to provide for a residence. But now, it has been enlarged to the property of the parents of the husband also. You have referred that August judgment. In August judgment is, daughter is also being given a right like a co-partner of the family and a share in the family property. She is a shareholder. That is, right of ownership is there to whatever extent it may be. But in case of daughter-in-law, there is no right of ownership at all. It is only and simply a right to residence. And now I will like to specify that this right to residence is limited up to a decree of divorce is there in between the husband and wife. Suppose a decree of divorce is being passed, so that domestic relationship in between the husband and wife and the daughter-in-law, father-in-law, mother-in-law, it will come to an end. And this obligation will go forever. So it is not forever, it is for very limited period and without giving any ownership right or title. So we cannot make any equality with the judgment of August. It is entirely a separate matter. This is simply a right to reside, and that is a right of ownership in the property. So they are two separate.
Advocate Sharma, but my question is that suppose daughter-in-law is staying with the and domestic violence case is on, whether she can go and stay in her parents' house because she is a co-owner of some share. Now it means if there is a bungalow and she is the owner of 1/3 portion of that bungalow, she can go and stay in that house.
Definitely, Mr. Goel, she is having dual rights. She is having a right in the parental property also, as well as she is having a right to residence in the in-laws property also. She's
So
having
in
double
both,
right.
so it means now she's having the right to stay wherever she wants to stay, and she
That
can stay a few days in the parents' house, few
Oh yeah,
days in
yeah,
the
yeah.
in-laws' house.
That's why I say that the right of equality is being exceeded now.
Okay,
Right
okay,
of equality is always there when they are equal. But
okay,
if one gender is being exceeding that right, then it is against the principle of natural justice.
I think now, thank you very much, Advocate Sharma. Now I think Advocate Drone is there. I can see him. Advocate Drone, can you hear me? Please
I
come.
can
No,
hear
please.
you. I can hear you.
Okay, you have, because your net has gone, so we could not hear your full submission. First, you finish that, then I will ask. Go ahead. Yes, Advocate Drone, you were saying
So
something
I will
at that time.
try to sum it up in a short passage. I would state that with great powers come great responsibilities, and right now the legislature has given the women of our country such humongous rights on her side that she can either live with her parents, she can live with her in-laws, she can live with her husband, which can create unnecessary litigation to harass the other side also. I speak on behalf of, as I am practicing on the criminal side for quite a lot of time, that the criminal intent and the criminal ideology in the mind of a person only sprouts for 5 seconds. When a person is going to commit or is going to file a complaint, the basic psychology that makes them commit that offense is the span of 10 to 15 seconds. But the ladies and the women of the country who have been bestowed upon with such powers should understand that the laws and the precedents which are being passed by the Supreme Court and the High Court should be used as a shield to protect their rights and not used as a dagger to use the laws which are being made to protect her against her in-laws or against her husband or against anybody else in the society. So in the end, I would like to say that this Supreme Court judgment is going to bring a lot of chaos in the society. I would part on the side of Mr. Sharma on this one, that yes, it is going to create some unnecessary litigation. It is going to create havoc. But if we can also educate the people, if we can also inform them, if we can also have more and more of awareness programs as we are having with Mr. Goel, that we can inform the woman of her rights and her obligations and the powers that she has been bestowed upon, the society can be using all these things in a positive manner also.
Okay, thank you, Advocate Drone. And Advocate Drone was very clear that this judgment is going to create a chaos, as Advocate Sharma has mentioned. But he says that if we will create more and more awareness about the judgment in a positive way, then. But one thing which Advocate Drone has mentioned is that the 5 second is the time when when they decide about to do something. Correct, Advocate Drone, which you are saying?
The criminal intention in the mind
Criminal
of the
intention.
person.
But Advocate Drone, I would like to add something. My experience says that 5 seconds passes very easily, but then with due respect and regards to the legal fraternity, it is the legal fraternity or the advocates or the lawyer, they put the criminal intent inside the brains of the client so that they file the litigation. Do you agree with me?
No, sir, I do not agree with that completely. The reason is that we are, we as lawyers are not in the business of the society or in the business of what is right and what is wrong. It is not our prerogative to understand that what is right or what is wrong. Our prerogative is the interpretation of law. The law has been created, and attaching the merit of the case, a person needs to be aware of what are the rights and what are the rights and what are the liabilities that he has. For instance, now in a case of a domestic violence, if a lady has been beaten by her in-laws or by her husband, and she is unaware of the sections and the severity of this offense, because in her village or in her in her own marital house, she has seen this thing happening as a very mundane event. It is not that we are feeling criminal intent or provoking her, but we are reprising her of her rights.
Okay.
So I would rather say that we are in the business of awareness and law.
Okay, so we can say that you are the legal warriors in one way to safeguard the society in a true sense. Thank you very much, Advocate Drone, for giving your frank views. I would like to go to Mr. Karthik Anand. Mr. Karthik Anand, you have supported this judgment. But as Advocate Sharma and Advocate Drone, although they are not happy with the judgment, and Advocate Sharma mentioned that these things are happening mainly in the metropolitan cities where the women are creating problem for the senior citizens. Just think a scenario when the father-in-law, the mother-in-laws are in 80s. They require proper care. At that time, and I don't know, maybe you might be knowing better because you are teaching in a very reputed law college, where what we are seeing in the society is that the daughter-in-law, instead of giving the care to the in-laws, father-in-law, mother-in-law, making fun of them, harassing them, seeing that they will be confined to a particular room or particular place only. Now, don't you think that is a harassment? And as Advocate Sharma says that the senior citizens maintenance of 2007, what is going to happen to that? Mr. Karthik Anand, please.
Yes, sir. Always we have to consider what's the main object of the act. Before passing of 2005 Domestic Violence Act or Protection of Women from Domestic Violence Act, we are having many other legislation, for example, 125 CLPC or even 498I of the Indian Penal Code, in order to claim any kind of maintenance or cruelty against husband or relatives of the husband. After having such legislation, why the parliament having such an intention to pass such a comprehensive legislation in order to protect the rights of the woman itself? So in the present community, we know that they are themselves, they are not protected as laid down under all other many cases, all under even 498 of IPC or under 125. The parliament itself considered it is not sufficient. So that is why whenever what we have to do, it may be a or after case, every case having its own merit. Based on one case, we cannot make any kind of generalization. Depends upon the factual situation only the court can decide, or based on the pleadings or evidence only the court can decide. It is a discussion around two legislation, whether the Domestic Violence Act 2005 will override Maintenance and Welfare Senior Citizenship Act 2007. So what the court can do? Under interpretation of the statute also, it clearly provides whenever reading a statute, the statute must be read as a whole in its context. What is the context means? Based on the scope and object of the act. Thus, one act provide benefit of the one category and another act provide benefit of the other category. The statute rule itself provide what the court can do. They can make a harmonious construction by protecting interest of the both the woman as well as senior citizen, because both are the same category in the society. So it is a duty of the court to see that it will not violate either maintenance or welfare of senior citizens act, or it should not affect any rights of the women under domestic violence act. By making a harmonious construction, the party can decide or the court can decide where actually the equilibrium is placed, where whether with the parent or the senior citizen was having 80 or 90 years each, or whether there is an aggrieved woman who has been lost her life after the marriage. So depending upon that, what the court is to consider in order to bring a balance between the two. Then based on the each case, it has to decide. So that is why
Okay.
it should not make such
Oh.
a chaos.
Okay, according to you, that court has to decide, but the practical experience says that once the lower court, the advocates goes there and they just give the citation of the Supreme Court, the court has to, the lower court will go with the citation, will not go with any other thing. They will not see the 2007 or 2005. Okay, this is the latest judgment of Supreme Court. It overruled everything. And that is the difficulty in the lower courts. Yes, academically, what you are saying is right. but the practical in India, which I have seen personally, not for
You
the
are
domestic
absolutely right,
violence.
Mr. Goel. You are absolutely right. This is daily happening daily in our society.
So now this is the thing. Anyway, thank you very much, Mr. Karthik Anand, for giving your views. And now I would like to ask Miss Nayak. Miss Nayak, you know very practically, you know, the women who are there are many women. I must not say, otherwise the women's lobby will be against me, but there are many who are creating lots of problem with the in-laws. And we know the very famous serial Saas Bhi Kabhi Bahu Thi. After all, mother-in-law is also a lady. She is also a woman. When we are talking about the rights of the women, mother-in-law is not a woman. When she is also a woman, what is the safeguard of the mother-in-law in this judgment? If by this judgment, the daughter-in-law have a right to create, and if during the divorce proceedings, she is sitting there, and as Advocate Sharma says, that there's a right that she has to be provided with the food. It means mother-in-law in 80s or 70s has to cook the food, provide the food to the daughter-in-law. What type of mental trauma the in-laws are having? Miss Nayak, please.
Yes, sir. Definitely, it is not easy. The whole law is not easy. Whatever you're doing, if a person you don't like is staying with you in the family, it's a trauma for both the in-laws and the daughter-in-law as well. So it is definitely it is the best thing to be cordially living. That is why I told you that it is always better that you maintain, and if there is dispute, see, when a woman comes to the household, it is not easy. It's not easy for the in-laws also. The mother-in-law also has to adjust to the new member that has come into the family. And as we all know, daughter-in-laws, it is very difficult to become daughters, towards the end. So that is very important. And here, when you're talking about doing the household work and everything, I think shared responsibility also should be maintained after, if it is shared property that you're talking about, even responsibilities have to be shared. It should be ideally like that, but I don't know how far that is going to happen. It is not like, if they are getting the right in the property, women should start bossing over their in-laws and making them do work and everything. That is not right. So that is very important. I think Mr. Sharma also maintained about, spoke about this, that it is very contradicting. Two things are, the person has to stay also, but the person is not doing any responsibility. It is very difficult.
Okay, thank you very much. And I'm sure, Ms. Nayak, now you will not get only the cases of daughter-in-law, you will be soon getting father-in-laws and mother-in-laws cases of the mental harassment. So today you have seen that this new judgment of 15th October, although the intention of the Supreme Court was very good, they wanted to safeguard the women as a whole, because whatsoever is happening in the society, everybody knows. But by doing this, they have not taken the care of the senior citizens, because this law is against father-in-law and mother-in-laws, and especially those who are in 80s or who are really senior citizens. So I am sure that this judgment may go for the review, and some constitutional bench will be formed and decide this. After all, it is a matter of the lives of not only the daughter-in-law but the parent-in-laws, as well as the husband, poor husband also. So
We hope so, definitely.
thank you very much for giving your views. And today, this program was live telecast by V4 News, Global TV, V4 Stream, Malnadu TV, News Gaon Se, Samvad Saroka News, as well as it was shown live on Facebook and YouTube. And our endeavor is to bring to you every day some serious topic. But as we have promised, every week, one day, we are giving the entertainment. And tomorrow, being Sunday, we are coming out with the media conference with Lal Goel. The day is for the entertainment. That is Suhani Yadein. And this Suhani Yadein will be, there will be 14 singers will be performed from different parts of country. They under the banner of Muhammad Rafi Foundation, Kolam. And the guest of the tomorrow's programs are Dr. C.V. Anand Bose, IAS, one-man expert commissioner on labor, Government of India. He's the chief patron of Mohammad Rafi Foundation, Kollam, Dr. D. Soman, President, Mohammad Rafi Foundation, Kollam, Mr. S. Unni Krishnan, General Secretary, Mohammad Rafi Foundation, Kollam, and Dr. Rachel Daniel, Treasurer and Program Coordinator, Mohammad Rafi Foundation, Kollam. So please tune in tomorrow for media conference with Lal Goel at 10:30 a.m. to enjoy the musical program tomorrow. Thank you very much, Advocate Ramesh Sharma. Thank you very much, Mr. Kartik Anand. Thank you very much, Advocate Arjun Drone. And thank you very much, Akshta Nayak, for joining and giving your expert views. Thank you, viewers.
Thank you, Mr.